It's now almost 3:50. We will enter a default. Notification was sent to him October 27th at his Auburn Road address, and it was not returned. Anything further on the Nelson matter, Mrs. Scott?
No, Your Honor.
Okay, thank you. Okay. Are you here on the Crumbley matter?
Yes, ma'am.
Okay. Are you ready to go?
You are, Your Honor, I'm ready.
Okay.
Yes, Judge. Mark Keys from the people we're ready to.
Thank you. Calling the case of People versus Ethan.
Good afternoon, Your Honor. Scott Kozak on behalf of the defendant.
Thank you. Calling the case of People versus Ethan Robert Crumbley. This is case number 216611. And again, your appearance as Mr. Keys for the record.
Thank you, Judge. Mark Keys on behalf of the people.
And Mr. Kosak.
Thank you, Your Honor. Scott Kozak on behalf of the defendant.
Thank you. And if you could state your full name and spell it for our court recorder, please.
Lieutenant Tim Willis, that's W-I-L-L-I-S, Will County Sheriff's Office.
Thank you. If you could please raise your right hand. Do you swear or affirm the information you're about to provide the court will be truthful, accurate, and to the best of your ability, so help you God?
I do, Your Honor.
Thank you. And what information do you have that would lead the court to believe that a complaint and warrant should be issued against Ethan Robert Crumbley?
Your Honor, on Tuesday, November 30th, would you like me to remove my mask?
It's up to you, whatever you feel most comfortable with.
Thank you, Your Honor. On Tuesday, November 30th at approximately 12:52 p.m., Sheriff's Office deputies were dispatched to Oxford High School, located at 745 North Oxford, Oxford Township, County of Oakland, State of Michigan, for the report of multiple gunshots being fired in and around the school. As deputies were responding to the scene, they witnessed numerous students and staff fleeing from the area. The first two deputies on scene immediately deployed to the area of the high school, taking a 15-year-old student into custody, later identified as Ethan Crumbley, 15-year-old Oxford Township resident. Preliminarily on the scene, the victims identified were a 16-year-old male who was deceased, a 14-year-old female who was deceased, a 17-year-old female who was deceased, a 17-year-old male who later was deceased at the hospital, a 14-year-old male, gunshot wound, 17-year-old female, gunshot wound, 15-year-old male, gunshot wound, 17-year-old male, gunshot wound, 47-year-old female, gunshot wound, 14-year-old female, gunshot wound, and a 17-year-old female, gunshot wound. As a result of this, Ethan Crumbley was lodged at Children's Village on homicide and attempt homicide with the on-duty referee approval. There was a weapon recovered from Ethan. It was a 9mm 6-hour automatic handgun. The additional investigation revealed that school security video of the shooting incident perpetrated by Ethan. The school security video shows Ethan exit a bathroom in a hallway and begin shooting at students, then proceeds to shoot students who are actively fleeing. He continues to shoot in a deliberate manner until apprehended by deputies. Two separate videos recovered from Ethan's cell phone, taken in a search warrant, depicted a video made by him the night before the incident, wherein he talked about shooting and killing students the next day at Oxford High School. Further, a journal was recovered from Ethan's backpack, also detailing his desire to shoot up the school, to include murdering students. A preliminary review of social media accounts indicate that Ethan Crumbley had access to a firearm and he practiced with a 6-hour handgun.
Thank you. And I just would ask the people, because these individuals weren't specifically identified by name. Is that because they're minors? Does that need to be done as it relates to each particular victim? They are in the complaint and warrant, but obviously not sworn to by the officer here.
Judge, they are listed in the complaint and warrant, and at this stage, I'd ask Lieutenant Willis to name those individuals so that the square to is consistent with their complaint and warrant.
Thank you. So if you can just go through each one, one by one, starting with obviously, well, actually with count 1, which indicates the terrorism causing death.
Okay.
Do you have a copy of the complaint and warrant?
I do.
Okay.
Count 1, did knowingly, willfully, deliberately, and with premeditation commit murder in the first degree, a violent felony that the defendant knew or had reason to know was dangerous to human life when intending to intimidate, coerce a civilian population, to it the Oxford High School community, and cause the deaths of Madisyn Baldwin, Tate Myre, Hana St, Juliana, and Justin Shilling.
Okay, thank you. And then you have 4 counts of homicide first degree, if you could just indicate those individuals that are deceased.
Yes, ma'am. So the deceased are Tate Myre, Hana St. Juliana, Madisyn Baldwin, Justin Shilling.
And then assault with intent to murder, there it looks like there's 7 victims, is that correct?
Yes, Your Honor.
Okay, if you could, those are the people that received gunshot wounds, if you could just indicate those individuals to be consistent with the complaint and warrant.
Yes, Your Honor. Elijah Mueller.
Hang on just a minute, let me make
Yes,
sure
ma'am.
we've got everybody. The first one I have for count 6 is Phoebe Author. Is that, I'm looking at the complaint and warrant.
Yes, Your Honor. I'm going off my notes. I apologize.
Okay, just look at the, if you could
Yes,
just do me a
ma'am.
favor, no problem. Just look at the complaint and warrant, it should be really easy. See, it says count 6.
Yep. Oh, yeah, I got it, Your Honor. I'm sorry.
No problem.
Did make an assault upon Phoebe Arthur with the intent to commit the crime of murder.
Thank you. And go ahead, count 7.
Yep. Did make an assault upon John Asudo, or Asudo, I apologize, with intent to commit the crime of murder.
And count 8.
Did make an assault upon Molly Darnell with the intent to commit the crime of murder.
And count 9.
Did make an assault upon Riley Franz with the intent to commit the crime of murder.
And count 10.
Did make an assault upon Elijah Mueller with the intent to commit the crime of murder.
And count 11.
Did make an assault upon Kylie Osage with the intent to commit the crime of murder.
And count 12.
Did make an assault upon Aiden Watson with the intent to commit the crime of murder.
Thank you. And it looks like the remainder of the counts 13 through 24, are possession of a firearm and the commission of a felony that attached to all of the prior felony counts. So, anything further?
No, Your Honor.
Based upon the information that you provided to the court under oath, I do find probable cause to believe that a complaint and warrant should be issued. Count 1, terrorism causing death. Count 2, 3, 4, and 5, homicide, murder in the first degree. Count 6, 7, 8, 9, 10, 11, and 12, assault with intent to murder. And as it relates to each of those felony charges, count 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, and 24, possession of a firearm and the commission of a felony to attach to each of those above indicated felony charges. If you want to come forward and sign the complaint and warrant, is there anything further regarding the swear to Mr. Keast?
Not regarding the swear to, Judge. Thank you.
Okay, thank you.
Yeah, pleasure.
Of course. I think that's it. You signed the complaint. I'll sign the warrant. Thank you.
Yes, ma'am.
Okay, it's my understanding that we may be able to arraign Mr. Crumbley today. Do we have, I've asked my law clerk if we can get him from, oh, here it looks like Children's Village. We'll have him brought in.
If I may,
Yes.
because the defendant is a juvenile under MCR 6.907, the prosecuting attorney must make a good faith effort for the juvenile's parents to be notified of the arraignment. I do believe that Ms. Nadine Hatton, who was initially appointed to this case, has made contact with the juvenile's parents. And I see on the Zoom screen indication that the defendant's parents are in fact attending this arraignment.
That is correct. I do see, I'm not sure that that is them, but they are identified as Mr. and Mrs. Crumbley parents, so I assume that they are in the courtroom. Their video is not on. I don't know if their audio is on. I assume that it is. Yes, thank you for bringing that to the court's attention and making a record of that. And it does, I can indicate that they actually, Mr. and Mrs. Crumbley, this is Judge Carniak. And could you just, you are the parents of Ethan Crumbley, is that correct?
Yeah, correct.
That's correct.
Thank you. If you could just state your full names, that would be great.
I'm Jennifer Crumbley.
James Crumbley?
Thank you very much. Anything else from the people before we bring Mr. Ethan Crumbley in and start the
No,
arraignment?
Judge. I would just like to speak as to bond, and I do have a motion to make at the appropriate time.
Thank you. All right. So, for arraignment purposes, calling the case of People versus Ethan Crumbley, case number 216611. Again, your appearances, Mr. Keast and Mr. Kosak.
Thank you, Judge. Mark Keast on behalf of the people.
Scott Kozak on behalf of Mr. Crumbley, Your Honor. Judge, before we continue, full disclosure, it was a last-minute call to bring me in as far as just the arraignment purposes. I know Ms. Patton, and I have an immense amount of respect for her. They have had a chance to review his rights with him. I have not. I would appreciate it if the court would provide me with an opportunity to at least review his rights with him, go over the entire situation, at least as far as we know, before we conduct the arraignment, just to make sure that we conduct everything appropriately.
Absolutely. We'll put you in a breakout room with Mr. Crumbley, and just let us know whenever you're ready.
And Your Honor, Nadine Hatton, that is correct, the information that you have been provided, and I apologize for interrupting. I was the attorney assigned to Ethan Crumbley on the juvenile matter. If Mr. Kozak does not mind, I would like to join the breakout room with him. I have had an opportunity to advise Ethan of his trial rights. I spent over an hour talking with Ethan, and so I want to make certain that he is comfortable and understands everything with Mr. Kozak. So if the court would allow me to join the breakout room, if Mr. Kozak does not have any objection, I would appreciate it.
Certainly no objection.
I think it's very appropriate under the circumstances, and we'll put the three of you in a breakout room. Just let us know when you're ready.
Okay, thank you, Your Honor.
Is Hatton in there? She can't be in there? It looks like she's frozen. All right. Once she goes into the breakout room, we'll just take a brief break. We want to make sure that she gets in there. You want to take her out and put her back in? Oh, there she is. Okay. All right. All right, we're going to take a few minutes recess and then we'll come back. And we'll try to handle those cases as quickly as possible, Mrs. Scott, afterwards. Thank you.
Thank you, Your Honor.
Well, this is probably over there in the corner.
Okay, back on the record on Crumbley. Mr. and Mrs. Crumbley, can you hear the court?
Yes, we can.
Thank you. I'm assuming that you would like to be put in the breakout room with your son and his attorneys, is that correct?
Yeah.
Okay.
Yes.
Yes, please.
Okay, we will do that. We will put you all together. Thank you.
Thank you.
All right, take another break.
Better late than never.
I didn't know if I was even going to get it. I just still, I want to go home. I was on a plane at 7. I'm not from around here.
They gave us one clip of girls about a minute's worth. That's been it. Did I touch on the social media
And Mr. Kozak, your appearance, or actually Mr. Keys, first your appearance.
Thank you, Judge. Mark Keith on behalf of people.
Mr. Kozak.
Once again, Your Honor, Scott Kozak on behalf of Mr. Crumbley.
Ms. Hatton.
Yes, Your Honor, Nadine Hatton, I was formally appointed to Mr. Ethan Crumbley as his juvenile attorney.
Thank you. And Mr. Crumbley, could you state your full name for us, please?
Ethan Robert Crumbley.
Thank you. Mr. Crumbley, at any time you do not hear or understand myself or any of the parties to the proceeding, will you please let the court know?
Yes.
Mr. Kozak, have you had ample time to talk to your client, as well as with Ms. Hatton, along with Mr. Crumbley's parents, to proceed with an arraignment?
Yes, Your Honor, I appreciate Ms. Hatton's presence as well as Mr. Crumbley's parents. I appreciate the court's time in allowing us to get acquainted. Mr. Crumbley was present for the swear-to because, for purposes of arraignment, if the court wants me to proceed, I can at this point in time.
Yes, okay, great. So then I'm going to, Mr. Crumbley, I'm going to advise you of your rights and the charges against you. Again, if at any time you do not hear or understand anything, will you please let the court know?
Yes.
You do have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand that right, sir?
Yes, I do.
All right. Count 1 does indicate that you did that on or about November 30th, 2021, Ethan Robert Crumbley did knowingly, willfully, deliberately, and with premeditation commit murder first degree, a felony that the defendant knew or had reason to know was dangerous to human life while intending to intimidate or coerce the civilian population, to wit, the Oxford High School community, and cause the death of Madisyn Baldwin, Tate Myre, Hana St, Juliana, and Justin Shilling, contrary to MCL 750.543F. This is a felony punishable by life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years, with reimbursements for government expenses incurred for this violation. This is otherwise known as terrorism causing death. Count 2 indicates that on that same date and time, November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Madisyn Baldwin, contrary to MCL 750.316. This is a felony that is punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is otherwise known as homicide or murder in the first degree, premeditated, being a juvenile defendant. Count 3 alleges that on November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Tate Myre, contrary to MCL 750.316. This is a felony punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years, also known as homicide, murder first degree, premeditated by a juvenile defendant. Count 4 alleges that on November 30th, 2021, and again, all of these, I'm sorry, are in the township of Oxford. I did indicate that, and I will continue to indicate that Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Hana St. Juliana, contrary to MCL 750.316, felony, life without parole, or a minimum sentence of 25 to 40 years, and a maximum sentence of at least 60 years. And this is in violation of MCL 750, again, .316. This is homicide, murder first degree, premeditated by a juvenile defendant. Count 5 alleges that on November 30th, Ethan Robert Crumbley did in the township of Oxford deliberately with the intent to kill and with premeditation kill and murder Justin Shilling, contrary to MCL 750.316, a felony life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is called homicide, murder first degree, premeditated by a juvenile defendant. Count 6 alleges that On November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault on Phoebe Author with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony, punishable by up to life or any number of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. This is also known as assault with intent to murder. Count 7 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in the township of Oxford, did make an assault upon John Asciutto with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life or any number of years, DNA to be taken upon arrest. This is also known as assault with intent to commit murder. Count 8 indicates that on November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault upon Molly Darnell with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life or any number of years, and DNA to be taken upon arrest, also known as assault with intent to murder. Count 9 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in the township of Oxford, did make an assault upon Riley Franz with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by up to life or any number of years, DNA to be taken upon arrest. This is called assault with intent to murder. Count 10 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Elijah Mueller with intent to commit the crime of murder, contrary to MCL 750.83, a felony punishable by life or any number of years, DNA to be taken upon arrest. Also, again, assault with intent to murder. Count 11 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Kylie Assange with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life or any number of years, DNA to be taken upon arrest. Count 12 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Aiden Watson with intent to commit the crime of murder, contrary to MCL 750.83, a felony punishable by life or any number of years, and DNA to be taken upon arrest. This is also called assault with intent to murder. There are now 12 counts of possession of a firearm in the commission of a felony. Counts 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, and 24. They do allege that on November 30th, 2021, in Oxford Township, Ethan Robert Crumbley did carry or have in possession a firearm, to wit, a pistol, at the time he committed or attempted to commit a felony, to wit, terrorism causing death. Also, murder in the first degree for count 14, murder in the first degree for count 15, murder in the first degree for count 16, murder in the first degree for count 17, assault with intent to commit murder for count 18, assault with intent to commit murder for count 19, assault with intent to commit murder for count 20, assault with intent to commit murder for count 21, assault with intent to commit murder for count 22, assault with intent to commit murder count 23, and assault with intent to commit murder count 24. This is contrary to the laws in the state, specifically MCL 750.227B. This is a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony of conviction. This is called possession of a firearm in the commission of a felony. Sir, do you understand all the charges against you?
Yes, I do.
Again, you have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand your right to remain silent?
Yes.
You also have, of course, your right to an attorney, and Mr. Kozak and Ms. Hatton have been with you, and that right will continue throughout all legal proceedings. And as it relates to anything further, we do need to set a bond. As it relates to bond, I will first let the, actually we do have pretrial services here to make a recommendation as to bond, and then we will let each attorney speak as it relates to that. So if the individual from pretrial services can come forward, state her full name and spell it for our court recorder.
Darla Finley, pretrial services.
I'm sorry, Judge, just before we do that, I just want to make sure it's clear that my client is standing mute. We're asking the court to enter a not
Oh,
guilty
I'm
plea.
sorry, yes. I will enter a plea of not guilty on his behalf, and we will set this for bond. Thank you, Mr. Kozak.
Darla Finley, pretrial services. DARLA FINLEY. The defendant was unable to be interviewed due to his location at the Children's Village. Therefore, that we have limited information. We do know that he's 15 years old, a resident of Oxford. He's a sophomore at Oxford High School. He has no prior juvenile record, no noted police contacts in Clemens. Given the serious nature of the matter, there's no conditions or combinations of conditions which will assure the defendant's appearance in court or safety to the community at large. Therefore, we recommend that bond be denied.
Thank you from pretrial services. Mr. Keast, anything you'd like to state?
I would, Judge, thank you. Because the defendant is a juvenile charged as an adult, the court must look at Michigan Court Rule 6.909, subparagraph 2. That court rule states that regarding detention without bail, if the proof is evident or the presumption is great that the juvenile committed the offense, the magistrate or the court may deny bail, subparagraph A, to a juvenile charged with first-degree murder. Judge, in this case, I am asking this court to deny bail as pretrial supervision has indicated. As a offer of proof, I think it's appropriate for this court to have a brief chronology of what happened on November the 30th, 2021. As you heard during the swear to, Judge, Oxford High School is equipped with surveillance video. We've had the opportunity to review that surveillance video just this morning. And what's depicted on that video, honestly, Judge, I don't have the words to describe how horrific that was that happened on November the 30th. It depicted just before 12:51 p.m., this defendant entering a bathroom with a backpack. A minute or two later, he exited the same bathroom without the backpack, but with a gun in hand. At that point, he methodically and deliberately walked down the hallway, aiming the firearm at students and firing. Right outside the bathroom, he began firing, Judge. After children started running away from the defendant, he continued down the hallway, again at a deliberate and methodical pace, pointing and aiming inside classrooms and at students who hadn't had the opportunity to escape. This continued on for approximately 5 minutes. The defendant went to another bathroom. As deputies arrived, he set the firearm down and he surrendered. Judge, a preliminary review of the defendant's social media accounts, his cell phone, as well as other document evidence recovered on the scene, showed that this defendant planned this shooting. He deliberately brought the handgun that day with the intent to murder as many students as he could. Judge, I believe no bond is appropriate. And again, like I stated, at the appropriate time, I'd like to make a motion to transfer this defendant from Children's Village to the Oakland County Jail.
Thank you. Mr. Kozak?
Your Honor, understanding the extreme nature of this case and understanding the circumstances at hand, and having spoken to Mr. Crumbley as well as his parents, I'm going to leave the setting of the bond at the discretion of the court.
Thank you. Anything further from Ms. Hatton?
Nothing further, Your Honor. I leave it in the discretion of the court.
Thank you, and I'm assuming you don't want your client to speak.
That's correct, Your Honor, on both Mr. Kozak and my behalf.
Thank you. I do believe, based upon all the information that's been provided to date, that a no bond, a denial of bond is appropriate pursuant to court rule, and I will order no bond on this case. Of course, your client does have a right to a preliminary exam within the statutory 21 day time period, as well as a probable cause conference. I don't know if the court should have set something, or have we set something, do we know? Oh, it's on the front of the file? Okay. All right. A probable cause conference will be set on December 13th at 1:15 in front of myself, and then an exam the following week on December 20th at 1:15 again in front of myself. Anything further from the people or the defense?
Thank you, Judge. I do have a motion for the court. The defendant is currently housed in Children's Village, if I may.
Yes.
Thank you, Judge. Under the same court rule, MCR 6.909, subparagraph B regarding place of confinement. Subparagraph 2. On motion of a prosecuting attorney or a superintendent of a juvenile facility in which the juvenile is detained, the magistrate or court may order the juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon the showing that the juvenile's habits or conduct are considered a menace to other juveniles. Judge, in this case, I can't think of a more appropriate set of circumstances for a transfer from Oakland County Children's Village to the Oakland County Jail. Now, this court must also look at the statute, and that's MCL 764.27a. I spoke with Lieutenant Tim Willis, who is the officer in charge and did the swear to this afternoon. He has confirmed that the Oakland County Jail can house this defendant in a location out of sight and sound from adults, and that's the standard in the statute, Judge. The Oakland County Jail is better equipped to handle this situation. They have done so in the past. They have done so in conformance with the statute. It is a more secure location, and I would ask that this court find that this defendant's conduct is a menace to juveniles by evidence of the simple fact that he targeted juveniles in this offense. Count 1 is a charge of terrorism via murder, Judge, and the evidence that will come out of the preliminary examination and the subsequent trial will show that this was a planned event, it was methodical in its operation, and it was done so to terrorize and intimidate others in the community, Judge. I do believe the Oakland County Jail is the appropriate location to house this defendant. Thank you.
Thank you. As it relates to that issue, Mr. Kozak and Ms. Hatton.
Thank you, Your Honor. All due respect to Mr. Keese, Your Honor, I want to remind the court, and when the court does need reminding, that these are allegations. He has not been found guilty of these issues or these charges as of yet. And I'm asking the court to, I'm objecting to the transfer at this point in time. I think the Children's Village is more than capable of monitoring him and maintaining the safety of the other residents of that facility. And I think at this point, Judge, if the court is going to consider this motion, I would ask the court to perhaps hold the ruling in abeyance until after the preliminary examination, at which point the court will have had a chance to have taken sworn and heard sworn testimony regarding these issues.
Regarding the issue itself, or regarding the fact that he shouldn't be moved?
Regarding the incident itself, Your Honor, and because I believe that's what the prosecution is using as a reason for the transfer in and of itself. That's evidence of the need to transfer.
Thank you. Ms. Hatton, anything further?
Your Honor, just very briefly, this court has already found that the proof is evident under 6.909. And I know this is a preliminary showing. Obviously, the defense has not had the opportunity to review discovery, neither has this court. However, it is alleged in these 24 counts that this defendant didn't commit first-degree murder on anybody, but he targeted other juveniles. And I believe that 6.909 subparagraph B is written specifically for a situation such as this. The Oakland County Jail is the appropriate location for this individual, Judge. It is, like I said, well equipped for this. They have the ability to keep this defendant separate from both sight and sound of other adults. This is appropriate in these circumstances, Judge.
Ms. Hatton, anything further?
Yeah, I concur in Mr. Kozak's argument. I will advise the court that as Mr. Ethan Crumbley's juvenile attorney, I did have an opportunity to speak again with Mr. Ethan Crumbley at the juvenile facility, Children's Village, as well as the individuals who are supervising Mr. Crumbley, Ethan Crumbley, at Children's Village. It's been reported to me, Your Honor, as the officer of the court, that Ethan has been cooperative. He is on suicide prevention there at Children's Village. He's not in general population. He's secluded and he's receiving one-on-one supervision. I would ask the court, based on that information, and that he is cloaked in the veil of innocence unless proven guilty, that he remain at Children's Village until after the preliminary examination. Given that Children's Village is suitable and able to maintain the safety of the other children at Children's Village, I believe it is appropriate at this time that Ethan remain at his current placement with the current conditions and supervisions in place until the preliminary exam, which is in a matter of days, December 20th, 2021, as this court has set.
Thank you. I'm going to ask to hear from Lieutenant Willis regarding safety issues and what is considered. If you want to come up to the podium, Lieutenant, and state your full name for us, please.
Lieutenant Tim Willis.
And Lieutenant Willis, I had heard from Mr. Keese that you thought it was appropriate for him to be moved to the adult facility. Is that correct?
Yes, Your Honor.
Okay, could you explain to me why you feel that way? I mean, besides the obvious of what is alleged to occur.
Right. So obviously, I agree with Mr. Keese about the incidents that I've witnessed via the video and all that stuff. But also the sheriff's office in the past has housed several juveniles. I've actually worked in that jail and know for a fact that how I just have all the confidence in the world in my team, the sheriff deputies at the jail, to secure him and keep him completely sequestered.
So how does that work? Explain what would happen to him and how he would, his placement would be.
Yes, Your Honor. We have several jail cells in and around, but typically where he would go, where he would be placed is a clinic area, and it's completely secluded off from the rest of it's the only thing, if there's a glass front door, but everything else is bricked in. So it's completely private, completely back and away, and a deputy monitors him.
So he'd have no contact whatsoever with any adult inmates, is that correct?
That is correct, Your Honor.
Okay, and he would be in that facility by himself?
Correct, and there would be no, again, the only adults he would hear would be the deputies working there, but
all right.
No inmates.
Thank
Not
you.
see them or hear them.
Thank you.
Yes, sir.
Under the circumstances and based upon the nature of this offense, still, of course, understanding that the defendant has a right to be presumed innocent until proven guilty beyond a reasonable doubt, I'm going to certainly err on the side of caution. I think it is within the court rules to do so, and I would agree with Mr. Keese. This is the perfect example of a case that should be done to protect other juveniles. So I will have him move to that facility. As has been indicated, that he will be in isolation and will not be in contact with any other adult inmates, but only that of sheriff's deputies. Anything further?
Not from the people, Judge. Thank you.
Thank you.
All right, the only other matter will be making sure that he has counsel at the date of the probable cause conference. I'm not sure if the court has already prepared on his behalf, but he will need court-appointed counsel at that point.
So I'm not sure who that obviously is done by circuit court. Do we know what's going on in that regard?
You will just need to fill out the court-appointed attorney request, Judge, and they will get that to serve.
Okay. So, all right. Mr. Crumbley, you want to make sure that you have counsel at each and every future court date. So we're going to make sure you have that paperwork today to fill out so that you will have an attorney present at your probable cause conference, your preliminary exam, and all future proceedings. Do you have any questions about filling out that court-appointed attorney form?
No, Your Honor.
Okay, thank you. Thank you, Mr. Kozak. Okay, if there's nothing further, we are in recess. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, may I approach the court reporter?
Sure. You want the complaint more? I don't have a copy of the original so far. You have to go look at copies.
What? I have yellow.
Go back on the record with the balance of these cases.
The other one will be green.
Mrs. Scott, I'm sorry for the confusion. If you don't mind, we're going to adjourn all those balance of the Auburn Hills cases since it's well past 4:30. We'll put them on your next docket.